Hi, good afternoon. This is a Bombay High Court judgment under the CGST Act, Central Goods and Service Tax Act. Citation is Vertiv Energy Private Limited versus Union of India. Here the petitioner challenged the show cause notice on the ground that the show cause notice itself was issued based on the Central Exercise Revenue Audit, SERA, who comes under the control of CAG. So the entire show cause notice, it is issued based on the SERA audit, who comes under the control of CAG. So petitioner made four contentions. One, in terms of the law laid down by the Bombay High Court in Kiran Gems Private Limited, CAG or its officials have no jurisdiction to audit private companies. So since this notice is issued based on the SERA audit, it has no jurisdiction. Point number one. Point number two. Show cause notice is issued with predetermined mindset. So it is invalid. Point number three. The documents and explanations placed before the authorities were not considered. And point number four. In any case, extended period of limitation cannot be invoked as there was no suppression. The material disclosed in the show cause notice shows no suppression. That is the contention of the petitioner. The revenue contested the contentions. Revenue said Kiran Gems, decided by Bombay High Court, that private companies cannot be audited by the CAG. It is appealed to Supreme Court. It is admitted and it is pending. That is point number one, contention of the department. Second contention is department said, revenue said, SERA audited department. It did not go to the private company and audit their accounts. It came to the department and audited the returns. So they found several discrepancies in the returns. Based on that, department also took initiative and they gave full opportunity. That is the second point. Then third, they said extended period of limitation can be invoked because there is suppression. And in any case, again, so notice they cannot come before the High Court. These are the contentions offered by the revenue. Bombay High Court, a very interesting judgment. Bombay High Court says, in Kiran Gems, that is a case which was decided by Bombay High Court, the notice was issued, the audit notice was issued to the private company directly by the CAG audit. Whereas in the present case, CAG audited the accounts of the department. CAG audit went to the department, they called for the records, and they found several discrepancies. Because the returns of the petitioner lying in the department was audited, it cannot be said CAG audited the petitioner or petitioner's accounts. This is point number one. Just because the CAG audit goes to the department, reviews the returns of the petitioner, it cannot be said that CAG audited the petitioner company or petitioner's company's accounts. This is point number one. Point number two. Bombay High Court says, if petitioner's argument, that is the present petitioner's argument, is accepted, then CAG would be disabled from exercising all its functions. Department cannot be found fault merely because they initiate action based on CAG's observations. So that is point number two. Point number three, the High Court says, relying on Supreme Court judgment, in case of Dhanvanti Devi, the High Court, wherein the Supreme Court held, the essence of a decision is its ratio and not every observation found. Because the petitioner says, based on Kiran Gems, show cause notice itself cannot be issued. High Court did not accept that argument. Just because there is a judgment which says CAG cannot audit the accounts of the private companies, that cannot be directly applied to your case. There they went directly to the petitioner, the private company. Here, they went only to the department and audited the returns. So it cannot be directly applied. This is the third point. Fourth point, court found that the show cause notice was not solely based on CAG observations. Based on the CAG's observations, the department downloaded the returns and other documents from GSTN, and they showed serious discrepancies. So it cannot be said that the show cause notice is mainly issued based on the observations of CAG audit. Fifth point, the affidavit of revenue stated adverse material was shared and sufficient time was granted to the petitioner. Petitioner will be given full opportunity. Even after that, now there is a show cause notice. They will be given full opportunity. This is what the affidavit of revenue says. This has been accepted by the Bombay High Court. Sixth point, sharing of observation of CAG. Because in the show cause notice, the revenue authority, he stated the observations. What are the observations of the CAG? So they said, the petitioner said, no, no, you are relying solely on the observations of CAG and issuing the show cause notice. But High Court says the sharing of observation of CAG was to enable the petitioner to offer his explanation. Such a sharing is a measure of fairness and in compliance with principles of natural justice. They don't want to hide anything from you. They want to give you everything. All the opportunity is given to you. Just because they rely on those observations in the show cause notice, you cannot say that is the sole basis for issuing the show cause notice. That is what the High Court says. Seventh point, by simply stating that show cause notice is predetermined, the allegation cannot be accepted without any concrete material or support. This is what the High Court said, because they said they challenged the notice based on it is issued with a predetermined mind. High Court did not accept it. Show cause notice merely records prima facie opinion. So you have every opportunity to go and dispute whatever is given in the show cause notice. You cannot say it is with a predetermined mind unless you give some concrete support, concrete proof to prove that it is predetermined. Then next point, eighth point, there are allegations of suppression in the show cause notice. In any case, court at this stage cannot pre-conclude whether that allegation is correct or not. So whenever there is a suppression is stated in the show cause notice, you cannot straight away say, no, no, it cannot be invoked. There is no suppression. All these things you cannot say before the court. We will not interfere at this stage. You go before the authority, explain to him, satisfy him, and then he may drop it. Why should we now decide whether the show cause notice is barred by limitation or not? This is what the court says. Eighth point. Ninth point. There are many allegations. Availment of wrong ITC credit, then payment not made within 180 days, etc. There are many allegations in the show cause notice. Court found that. And the total tax of GST is to the tune of rupees 231.78 crores. I repeat, the extent of tax evasion alleged in the show cause notice is to the tune of rupees 231.78 crores. Then many clarifications were called for by way of email, by way of notices, etc., which was not properly replied by the petitioner. So the court says, no, we cannot accept this. Finally, the court said, the petitioner is only taking a chance to stall the show cause notice. You want to get it quashed somehow so that there is no proceeding against you. This is your intention. Main intention is to prevent the revenue authorities from taking any action against you. So court imposed a cost of rupees 1 lakh on the petitioner. Then the final and small observation by me is the amount of tax evasion is approximately to the tune of 231 crores. So is it carelessness on the part of department or something more that meets the eye? I don't want to explain it more than this because the amount is not a small amount. It is 230 crores. Anyway, the Bombay High Court did not accept the contentions of the petitioner and directed the petitioner to appear before the authorities, offer all their explanations, and then proceed from there. Thank you very much. Have a great day.